This is the Comp Mass Ethics lecture. Within the last couple of years, the SJC has made some changes to the Mass Rules of Professional Conduct. You're lucky because they are more now in line with the model rules than they have been, but there are still some important distinctions. So I'm going to go over the distinctions that I think you need to be aware of in the event that there are some ethics questions on the essay portion of the bar. If you see a lawyer giving advice or doing anything in an essay question, you have to consider whether or not there are some ethical considerations that should be addressed, even if it's just to raise the issue and not resolve it. So first, Rule 1.2, which is scope of representation. Massachusetts has a specific provision that allows a lawyer to accede to the reasonable request of opposing counsel that do not prejudice the client, and being punctual, fulfilling professional commitments, and avoiding offensive tactics, and treating other persons with dignity and with courtesy. That language is not in the model rule. Additionally, there is comment that suggests that the Massachusetts lawyer should bring up the issues of alternative dispute resolution as part of handling a case in which the retention or the representation was not expressly for the purposes of engaging in an alternative dispute resolution matter. 1.6, we have a very specific definition of the kind of information that is covered. We have not dispensed with the adjective confidential that appears before the term information in any of the rules. What that means is that in Massachusetts, the board and bar council and the court are much narrower in their interpretation of the kind of information that is covered by the duty of confidentiality and the duty of privilege as well. The model rule just says information. So technically, under the model rules, any information at all that one gets in the course of the representation must be considered confidential unless it falls into the general requirement of client consent or to assist in the execution of the representation. That is the impliedly authorized language. So first, with respect to B2, and this is the permissive disclosure, if a lawyer receives information that somebody, not just the client, but anybody, is going to engage in a criminal or fraudulent act that the lawyer believes is likely to result in substantial injury to property, financial, or other significant interests of another. So unlike the model rule, which requires that the crime or fraud be committed by the client and it only goes to property or financial interests, our rule does not require that the information be related to the commission of a crime by a client. It could be the commission of a crime by any third person. And if it relates to another significant interest other than financial or property, then the lawyer again has the possibility, or at least has the right, to disclose the information. And these are all mays and not must, unless 4.2, when dealing with a third person, requires that you divulge the information. We have a comment in Massachusetts which is helpful in defining what the term confidential means, and that's comment 3A. And under the comments, which are of assistance to the lawyer in interpreting, and to the board, et cetera, in interpreting the intent of the rule, the term confidential information is, for example, included by protected information that's protected by the attorney-client privilege, information that's likely to be embarrassing or detrimental to the client if disclosed, or information that the lawyer has agreed to keep confidential. It does not generally include a lawyer's legal knowledge or legal research, or information which is generally known in the legal community or in the trade field or profession to which the information relates. So if this is something that has been disclosed, particularly by the client or by anybody, and was in a newspaper which is easily accessible and in the not too distant past, then it is certainly possible that the information is not going to be deemed confidential, and therefore it can be disclosable by the attorney without risk of violating the rules of professional conduct. Comment 8A says that, for example, if you interfere with somebody's right to vote, if an individual does that and the lawyer receives information that somebody has interfered with the client's right to vote or some other third person's right to vote, that's the kind of significant interest that would allow the lawyer to disclose the information under mass rule as opposed to model rule. We also have a lengthy notice of disclosure comment, so that the client is probably going to have to be told that you are disclosing this otherwise confidential information. Are conflicts of interest under Rule 1.8? The model rule prohibits the disclosure of information relating to the representation of a client to the disadvantage of the client, and this is whether it's a current client or a former client under the following rule. However, in Massachusetts, it cannot be disclosed either for the disadvantage of the client, for the lawyer's advantage, or the advantage of a third person. So if a lawyer wants to disclose information and the client refuses to allow the lawyer to disclose what was confidential information, what is confidential information, because the lawyer wants to use the information for the lawyer's own benefit, under the model rule, that would not be an impermissible disclosure. Under the mass rule, it would be. In defining the term in C, substantial gift, we do not recognize that substantial gift can be given by an individual with whom the lawyer or the client maintains a close familial relationship. So somebody who you call aunt or uncle because of their close relationship with your family and with you, who's your client and wants to give you a substantial gift. If it's up to the client, that may be okay, but you're not allowed to solicit a gift even from Uncle Fred, who's lived next door and has no one to leave the house to in his will, and you're going to be drafting the will. You can't say to Uncle Fred, gee, since you don't have any heirs, that would be a good idea if you left it to me. That would be impermissible in Massachusetts, whereas it may not be under the model rule. We have not adopted the blanket allowance of the firm to which a disqualified lawyer goes of continuing in a case. The model rule has a pretty much open permission of a new firm to which a conflicted lawyer migrates, allowing that firm to continue or to take a case so long as the disqualified lawyer is adequately screened. In Massachusetts, that is not always possible. In fact, our screening rule is narrower. We would permit screening so long as the personally disqualified lawyer has either no material information relating to the case, which would mean they either did not have any conversations or see any files or anything, so they have no confidential information, or the personally disqualified lawyer had neither involvement nor information relating to the matter sufficient to provide a substantial benefit to the new firm. So if the lawyer that migrated to the new firm either worked on the case or has significant information which could be beneficial to the new client, then screening is not adequate and the new firm is going to be disqualified. So Massachusetts has maintained a much narrower immunity for new firms in which there is now a disqualified lawyer or a personally disqualified lawyer working. Lawyers who are involved, as a comment under the definition of firm, lawyers who are involved in the same unit of a legal service organization and constitute a firm, but not those who are employed in separate units. There's also some non-conventional, which means it's not in the model rule, discussion of what constitutes a firm in comment 1 to Rule 1.10, which is what I'm talking about, that you might want to look at just because it's maybe an issue if you've got one or more lawyers who are practicing together, but they are or are not holding themselves out as a firm for the purposes of liability or other reasons, civil liability, rules violations, things like that, whether somebody is or is not a firm sometimes is important. With respect to our IOLTA rules and trust property rules, we have some additional requirements and restrictions that are not contained in the model rules. Our rules require that a lawyer take his or her fee out of the client's fund at the earliest possible time. If you take it out and you are then notified of a dispute as to whether or not you are entitled to that money, then the money must be returned until there has been a resolution of the dispute. You have to notify a client whenever money is withdrawn from the client's fund, whether it's withdrawn to pay a third party or withdrawn to pay your own fee, and there must be an explanation for where the money went that is given to the client. Trust accounts are supposed to be located in Massachusetts, but they can be located elsewhere with the client's consent. An IOLTA must be located in a bank in Massachusetts. You must inform the bank that this is a trust account for the benefit either of a particular client or it's an IOLTA account. Massachusetts has very specific record-keeping rules. You must keep a sub-record for a sub-ledger for every client, even if it's part of an IOLTA account. So there has to be, for every client whose money is in an IOLTA account, you have to have a separate sheet that notes the amount of money that came in and the amount of money that goes out and for what purpose. All checks that are issued must be on pre-numbered checks. You can't just pull a blank check from the bank's stash and then put a number on it and an account name and take it out. It cannot be made payable to cash or to bearer. If it is for the purposes of fees, all fees must be taken out of an IOLTA or trust account by check that is payable either to the lawyer or the firm. If you represent a lending entity, such as a conveyancing institution, you can have a specific conveyancing account, and more than one client can be part of that specific conveyancing account and need not comply with the IOLTA rule. You must retain records for 6 years and has to be a check register, a check ledger. You must reconcile each account and each sub-account no less than every 60 days. Both legal fees and expenses that are advanced to the lawyer. So whether the client gives you money for legal fees, the client gives you an advance to be used as costs and expenses relative to the representation, or both, those categories of monies must be placed in the IOLTA account. In comment 2, the Rules Committee has indicated that flat fees do not have to be placed in an IOLTA account. That is a fee which is earned upon payment. The fee for the representation of X in a driving under the influence case is going to be $5,000 no matter how long or how short it takes or what kind of involvement in the representation the lawyer is required to have. But if you put it in an IOLTA account, then it is subject to the provisions of our rules. So the definition of flat fee or fixed fee in this comment is a fixed fee that an attorney charges for all legal services in a particular matter or for a particular discrete component of legal services, whether relatively simple and of short duration or complex and protracted. So that's an issue that's not resolved in the model rules. It is for the purposes of our rules. You don't have to put it in your IOLTA account, but if you do put it in your IOLTA account, then it's subject to the IOLTA rules, which means that it has to be withdrawn by a pre-numbered check. It has to be made payable to the lawyer or the lawyer's firm, and you have to notify the client that you've taken it out. If the lawyer is worried, there's a comment 6, if the lawyer is worried that his or her fee is going to be taken by the client, if you pay the client everything, let's assume that there's some resolution of the matter, or some money comes in for the client and part of it is your fee, and the client says, I want all of it, then it is not necessary to turn over the entire amount to the client if you have reason to believe the fee portion is not going to be ultimately turned over to the lawyer. Then it goes into the disputed funds provision, which requires a lawyer under both the model rules and the mass rules to hold the money in the account until there is a resolution of the dispute as to who owns the fees. Massachusetts in 1.16e has a specific and detailed rule on copying files and who has to pay for the copies. In Massachusetts, you are not permitted to withhold a file for any purpose whatsoever if the withholding of the file is going to prejudice the client. The general rule is that a contingency fee case, you've got to turn over everything, even prior or especially prior to the conclusion of the case if you're discharged. In a fee case where the fees and costs are being paid along the way, lawyer is not required to turn over the work product for which the client was supposed to pay and has not paid, except that we have this rule that says you can't withhold it, even if the rule would allow you to, if it's going to cause prejudice, unfair prejudice to the client. Next is Rule 3.3, candor to the tribunal. We have a very specific subsection E, which tracks the Mitchell case, and it sets forth the steps that a lawyer is supposed to take depending on when in the course of the representation it becomes known to the lawyer that the client in a criminal case is going to give false testimony. So you're supposed to discourage the client from doing so. If the information comes to your attention before you take the case, then you're supposed to decline. If it's in the course of the representation and you can't persuade the client not to give false testimony, then you're supposed to ask for a hearing before a judge other than the judge who's going to preside over the trial, and you have to make an application to withdraw ex parte, and you're allowed to disclose only the kind of information and only the nature of information which is to the extent necessary to effectuate the withdrawal. If you're in the middle of the trial, then the lawyer need not file a motion to withdraw. The lawyer is supposed to call upon the client to either rectify the testimony if it's already been given or to decline to testify falsely. If the client has not yet testified and insists on testifying in a criminal case, then the lawyer, is supposed to ask the judge permission to inquire in a manner that will not allow the lawyer to foster or facilitate the crime of perjury which the lawyer believes is going to occur. The lawyer is not supposed to reveal any confidential information. It should be enough that the lawyer tells the judge at a sidebar conference that it believes that the client is going to create a 3.3e problem for the lawyer, and the lawyer should ask the judge for the ability to inquire in the narrative. The lawyer is also not permitted to argue any of the testimony that the client has given that's the subject of what the lawyer knows is false testimony. The definition of what a lawyer knows or doesn't know is generally that there has to be some firm basis in fact. In fact, under the comments to this rule 11b, the lawyer must act in good faith and have a firm basis in objective fact that the client is going to testify falsely or has testified falsely in the course of the case. With respect to paying a witness, we have a specific rule. The model rule is very vague and talks about doing and not doing anything that violates the law. In Massachusetts, specifically says it is a violation to pay, offer to pay, or acquiesce in the payment of compensation to a witness contingent upon the content of his or her testimony or the outcome of the case. That's anybody. You are allowed to pay an expert witness whose testimony you supposedly know, but it cannot be, I'm going to pay you if you testify that there was no negligence in the design of this particular item. However, it is permissible for a lawyer to advance, guarantee, or acquiesce acquiesce in the payment of expenses incurred by a witness in preparing, attending, or testifying, reasonable compensation to a witness for loss of time in preparing, attending, or testifying, and a reasonable fee for the professional services of an expert witness. Under the Mass rules, it is not permissible, it's a violation, to present, participate in presenting, or threaten to present criminal or disciplinary charges solely to obtain an advantage in a private civil matter. And if you are appearing in a professional capacity before a tribunal, you are not permitted to engage in conduct manifesting bias or prejudice based on race, sex, religion, or national origin, disability, age, or sexual orientation, unless that is an issue that is raised in the proceeding. Solicitation of clients, the Mass rule is generally the same with respect to live, real-time, or in-person solicitation. However, in Massachusetts, the solicitation bar arises only the representation is solicited for a fee, not when the model rule says when the motive, significant motive, is the lawyer's pecuniary gain. In Massachusetts, it has to be solicitation where it is for a fee, not where you think maybe you're going to get a fee. It has to be for the fee. Solicitation from a prior client is permissible. If you are soliciting business from a lawyer, whether it's the lawyer's own representation or you are attempting to get business from a lawyer who has a case and you want to in some way participate in the representation, that is permissible. And remember that in Massachusetts, it is permissible to share fees with a lawyer not in the same firm as long as the fee is not overall clearly excessive, which is the standard in Massachusetts. You also can solicit work from somebody who is a grandparent of yours or your spouse, or a descendant of the grandparents or of the spouse, of your spouse. Also, you may solicit business in Massachusetts from an organization, meaning a corporation, a nonprofit, or governmental entity, if in connection with the activities of the organization or a person engaged in trade or commerce as defined in 93A. So the bar against solicitation is limited to real live persons and not to businesses. So you could, if you think a business needs a lawyer, you can call up and solicit business as long as it does not involve coercion, duress, or harassment. The target potential client has made it known that they do not want to be solicited, or the lawyer knows or reasonably should know that the physical, mental, or emotional state of the target is such that the target cannot exercise reasonable judgment at the time. That's not obviously likely to occur when there's a corporation that's the potential client. Lawyers are permitted. We have a more broad specialization rule. Lawyers may hold themselves out. This is 7.4. Lawyers may hold themselves out publicly as specialists in particular services, fields, and areas of law if the communication is not false or misleading. Such holding out includes a statement that the lawyer concentrates in, specializes in, is certified in, has expertise in, or limits practice to a particular service, field, or area of law. Lawyers who hold themselves out as specialists shall be held to the standard of performance of specialists in that particular field of law, unless the name of the certifying organization is clearly identified in the communication. It is not required that it be a group. If you are certified by a group and you're advertising that in Massachusetts, it is not necessary that it be either approved by the American Bar Association or by the state. But if you do that, you must say this is a private organization whose standards for certification are not regulated by a state authority or the American Bar Association. So, example, if you become a fellow in the American College of Trial Attorneys, which is a very prestigious group, you can put that on your letterhead, but you have to say that the American College of Trial Attorneys is a private organization whose standards are not regulated by either the Commonwealth of Massachusetts or the American Bar Association. Finally, R 8.4 has a section that is a general adversely reflects on his or her fitness to practice. So even if your conduct doesn't fit into something else, if it's like conduct on becoming an attorney, technically Bar Counsel is permitted to bring a charge under 8.4. It's fairly broad, but hopefully Bar Counsel won't abuse the existence of that sort of blanket conduct unbecoming prohibition.